Hello, this is Dr. T, and this video is being prepared or rather in place of a lecture that unfortunately had to be canceled in week 11. One of the sections of this course um, did have the lecture, but the other section did not. And this video is meant to provide some of the key substantive information covered in week 11 to, really both cohorts of students, but especially the section in which we had to cancel the lecture. And again, this is for week 11. The topics that will be considered in this lecture video include transparency and explainability. But actually, before we get into transparency and explainability, I'll actually go back to consider some issues related to intellectual property concerns that may come up when a company decides to outsource certain data analytics services. And I am covering that topic with a view to ensuring that you feel as comfortable as possible in the preparation of the contracts assignment in this course. And as we get into that, I want to remind you to please ensure that you review the instructions for the assignment. You'll see that or that you have been asked to submit a memo. I have no real preference in terms of whether or not you submit a memo that is a very typical business type of memo, or whether you submit something that looks maybe perhaps a little bit more like um, a, a, uh, a paper or an essay. What matters is that you do not submit a collection of bullet points, number one. And number two, please do not, absolutely do not provide draft contractual provisions. I'm interested in reading um, your uh, your analysis and your summary of which types of contractual provisions ought to be included and why, but don't please don't include sample clauses or sample language for the proposed provisions. It's enough to say, for example, the contract should include this type of provision, say a variation clause, to provide an explanation of why, and to provide, of course, a description of what a variation clause is. So, for example, you might, as I've already proposed, you might want to recommend the inclusion of a variation clause. You would then explain what a variation clause is. This is a contract clause that provides a means of um, amending the contract or changing certain contractual provisions if certain conditions are met. And then you'd want to explain why it is so important to have that kind of provision. And of course, in Ontario, the law as it currently stands for contracts is that if a party needs to vary the terms of contract, generally speaking, the courts require that new consideration be offered. And that can sometimes create a real problem for businesses. And as a result, we recommend trying to get ahead of the issue by ensuring that the contract itself contains provisions that provide a mechanism for varying the terms of the contract. If you don't have a variation clause, things get more complicated for you if you do need to amend the terms of the contract. So this is what I'm looking for, identification of the types of clauses, uh, a brief description of what that clause is, not what it should say, but what it is, what it does, and of course, an explanation of why. Please make sure you review the assignment though, so that you know there's I think 3 parts to it. Please ensure that you review the assignment so that you know the prompts that you are being asked to consider. In terms of citation styles, please remember that if you draw on the work of another person, and that can be their actual words, but also it includes their ideas or how they've organized their thoughts about a certain topic. If you're using someone else's intellectual property, you have to have a citation. I don't care what format of citation you use, as long as you use a form of citations, okay? So I recommend that you use whatever approach you are most comfortable with, that you understand, that will be easy for you to use. I'm not fussy about whether it's IEEE, APA, MLA, Chicago style. That doesn't matter to me. What matters is make sure you have those citations in there. Okay, so some pro tips, so to speak, about contracts. There is definitely some useful information in the slides from week 10, but I did want to take a moment to ensure that you realize that the issues in the assignment are not limited to issues related to complying with PIPEDA. The company also needs to consider very carefully the impact that the current structure of Canadian intellectual property law may have on outcomes in the situation where this company Hogtown is outsourcing a bunch of data analytics services to 905 Analytics. And in order to understand what the issues are, we have to take a brief step back and remind ourselves a little bit about Canadian intellectual property law. Now, Canadian intellectual property law includes law that pertains to, of course, intellectual property, but this is property that is, typically speaking, intangible, right? So there isn't a hard asset that you can point to and say, oh, look, here it is. We're talking more about um, well, sometimes concepts, but we're talking here about patents, copyrights, to a certain extent, industrial design, and trademark. And we're going to focus mostly on copyright and intellectual patents, and discuss how these areas of Canadian law intersect with data and the ownership of data and the ownership of algorithms. Let me preface what I'm about to say with a brief explanation about what property really is. We often think of property as the thing, the hard asset, but in actual fact, property is better understood as a bundle of rights. It gives you a bunch of rights to deal with a particular thing. And what's critical is it's a bundle of rights, which means that often a person can break off one of the sticks in the bundle and sell it or lease it to someone else without losing the entire ownership of the item. Now, one of the most important rights in the bundle of rights is the right to exclusivity, the right to the exclusive use and enjoyment of the property for oneself. This means that you can exclude other people's use of the property and essentially monopolize it, keep it entirely for yourself. Now, this raises some interesting issues when we're talking about information and whether or not information can, in fact, be owned. But let me first help you understand why this is such an important issue. And the issue relates to the nature of algorithms and data themselves, right? Let's take a different form of property, a tangible form of property. Suppose we have ownership of a car. If I've got ownership of a car, um, there's something very tangible. And if I'm using it, someone else cannot be. If it is stolen from me, I am fundamentally deprived of the use and enjoyment of the vehicle. Information's different. Information can be copied and shared without compromising the person holding the information's use and access to the information, right? Cars can't be duplicated. Information can. And that makes it a little bit more difficult to protect your ownership interests in information because it can be copied and used by more than one person at one time. And in fact, it can be copied, used by more than one person without the person who generated the information or collected it in the first place even knowing. And that's why when we're in an economy where information is so incredibly valuable, where it is often the key asset, we have to give special thought to how we are going to protect our interests in the information. So let's turn our minds to whether or not you can have a bundle of rights in information, data, and algorithms. And here's the thing, you can't own information. Um, you can have an interest in information, especially personal information, and your interest in the information can um, can mean that you're entitled to certain rights, but information cannot itself be owned. Facts, for example, can't be owned. And there are many reasons why, but I'll highlight for now just the public policy issues that relate to um, potential ownership of a fact, right? One person can't control for their own exclusive use and enjoyment the fact that something happened, right? Newspapers can report on some occurrence that occurred, and generally speaking, we want to encourage more than one perspective. Information, generally factual information, um, therefore cannot be owned. Well, what about the expression of information? Um, this starts to get us into more complicated areas. Let's think about copyright for a moment. Now, copyright provides the creator of a work with certain exclusive rights over the work, including the right to allow the work to be duplicated. What copyright does not do is to protect what the information actually does or means. So think about computer code for a moment. Let's suppose we have the computer code that underlies a particular algorithm. We've got that computer code written down in some format, right? And of course, to obtain copyright over a work, the work has to be original, number one, and number two, it has to be contained in a fixed medium. That means it has to be recorded in some way, either written down on paper, a photograph, or a digital record that has been created with the information. But copyright doesn't protect what the algorithm does. Copyright protects the replication of whatever medium has been used to capture the code itself. So if the code is on a piece of paper, copyright protects your exclusive rights to who can copy uh, the 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 paper, right, with the code, or who can retransmit it, rebroadcast it if it's um, some kind of performance. But that doesn't necessarily protect what the core interest in the code is. The core information in the code is often, or the core value in the code is often, what does it do? What does it accomplish? And that cannot be effectively protected by copyright. So you might have copyright over computer code, but that doesn't actually protect you or give you exclusivity over what the code does or how it operates. If I happen to have a photographic memory and you show me your code and I am able to memorize exactly what it says, and then I go home and I type it out in my computer, uh, I have not violated your intellectual property rights. And that's really important to understand. The other complexity around codes and algorithm um, pertain pertain pertains to how patent may or may not protect code and algorithms. And there are two important things to note here with respect to patents. First, to obtain a patent for something, it has to have a physical existence, or the operation of whatever it is that you're getting patented has to result in an actual discernible effect or change in the real material world. So a computer process that you have created might be patentable if it results in some change in the real world. If it changes the physical reality of how a computer processes things, for example, you can probably get a patent for it, if other conditions are met, of course. But if the algorithm or the code is simply very good at sifting data and identifying trends and patterns, but doesn't result in any real change in the actual world around us, you will have a lot of difficulty actually getting a patent for that. So that's the first complexity, the fact that for something to get to be patentable, the thing has to have either an actual physical existence, or um, its deployment has to result in a discernible effect or change in the real world. The second challenge is that, as a matter of basic public policy, you cannot get a patent for something that naturally occurs. If, for example, scientific insights and scientific principles are not subject to patent, nobody can own, for example, the law of gravity, right? There are many good reasons for that. For now, it will be sufficient for us to note that if something is a natural phenomena, or you're capturing a basic scientific or mathematical principle, you cannot obtain a patent for that thing because of public policy issues. Now, algorithms at their core, right, they're math. At the end of the day, an algorithm is just really fancy math, and you cannot get a patent for mathematical principles. So there are some very real limitations around using something like patent to protect your algorithms or your code. Let's hop back to the question of a database, for example. Suppose we've collected a large amount of data relating to our customers or something, and we've got uh, we've created basically a compendium of data. We've built up our a particular data set, and let's think about, can we use copyright to protect our interests in that database? And the answer is, as it often is in law, it depends. What does it depend on? Well, again, first remember that what algorithm or code does is not going to be protected through copyright at all, maybe through patent, but you're running uphill. Um, what does copyright protect? It does protect the creator of a work. It protects their interest in the control over who has access to the work they've created. Can it be copied, and so on. Um, with respect to databases, they would fall, if they are to be protected at all, they're going to fall within the category of literary works. And literary works or literary works do include functional works, right? Something doesn't have to have artistic value or merit to receive copyright protection. Okay, so functional works, things like collections of data, potentially could obtain copyright. Okay, computer codes, lists, instructions, these could be copyrighted under certain circumstances. And basically, in terms of those circumstances, there has to be some evidence of the exercise of human judgment in order to receive copyright protection, right? Copyright protects humans' interests, human effort, human creativity. And so if you generate a database of information by pressing a few buttons, that in and of itself might not be protected by copyright because it didn't really require the exercise of human judgment, skill, or insight. But if you have expended some actual mental energy and human judgment and discernment in how to um, organize and collate certain lists or codes or pieces of information, it is possible that you may be able to protect that work as a literary work under the copyright protection regime. And in particular here, I want to draw your attention to protections that are given for compilations. Compilations are protected by copyright if they are original, you created them, you aren't copying them, and they're in some fixed form. An electronic fixed form is fine, that meets the test. Um, a compilation itself, the definition includes a work resulting from the selection or arrangement of data. But again, I add that caveat that the courts and of course the Copyright Office, they are going to be looking for some exercise of human judgment or effort. It doesn't mean that there has to be a lot of human judgment exercise to trigger copyright, but it cannot be as simple as, well, I press a button on the computer and this is what is yielded. That, typically speaking, isn't enough. However, it is very helpful that if you have taken the time to do some um, um, selection or arrangement of the data, uh, you may be able to get copyright. That does provide a good stepping stone to getting some protections. So first, if you are if you've compiled information, organized it into some kind of database, and you're about to share it with a company you've hired to do data analytics on an outsourcing basis, one of the things you want to make sure you are clear about is the ownership of any copyright that may exist in the works. So you want to make sure there's a provision in a contract that essentially stakes your claim, name it and claim it. Any copyright in the databases belong to us. And that helps ward off potential litigation in the future simply by stating out front, no, this is ours, right? You can protect yourself and protect yourself from future disputes. Let's talk about confidential information, though. Confidential information being um, a very particular type of information that falls within a particular definition as set out by the courts. And this is information uh, that has value. And here, when we protect this type of information, um, we're not necessarily using copyright. Copyright is really about the replication of the medium that contains the original work. Okay, so copyright would protect the duplication of a database. Um, but other dimensions of information that are incredibly valuable might not be protected simply by restrictions on the duplication of the database. There are other types of insights and information that you simply want to protect from disclosure, and it's not necessarily about the duplication of the information as much as it is about the fact that the information has economic value because it is being held as confidential, and um, it's not about controlling. Sort of gets in, I have to be careful here because it sort of gets into some nuances. um, but let me take a step back and say there's certainly some information that falls within the realm of confidential information, but that might not be protected under copyright. So that's one of the issues that we have to be concerned about. And the other issue is understanding that even if you do have copyright, the way copyright protects you may not suffice under a certain set of circumstances. Okay, so this brings us to confidential information, and here I have to take a step back and underline that you cannot own information. You can own rights to replicating information, but you can't own information itself, right? So there are aspects of data analytics and the insights from data analytics that that might not be the sort of thing that can be adequately protected through patent or copyright, or these protections may not attach at all. Okay, so here we've perhaps put this broadly under the category of confidential information. So what is confidential information? The Canadian courts have told us confidential information is information that has economic value as a result of not being generally known. Efforts are taken to keep the information confidential, and the information we're talking about, is not generally known in the industry. One example of confidential information is the recipe for Coca-Cola. Okay, you cannot patent that recipe. Oh, my cat is about to jump out on the desk. No, don't touch that. No, what you doing? Okay. Uh, Sorry about that. Henry the cat, who very rarely actually makes an appearance, is lurking around my keyboard, and I don't want him to sit or. Oh, there he goes. Okay, blooper reel, am I right? Okay, so Coca-Cola, the recipe for Coca-Cola is something that's protected as confidential information. It's not patentable. Um, Copyright, again, protects the replication of the recipe. So if it's written down, we can't photocopy and sell the photocopies. But if I have a photographic memory and I see the recipe and I then um, sorry, the cat is no eyeing these plants. Hold on, hold on. Okay, I recently received some very beautiful flowers, and my cats are going nutso over them because they really like to chew plants. So I'm just going to sit here with them on my lap and hopefully keep the cats away. Um, I don't even remember what I was saying, and I'm going to be honest, I don't want to go back and re-record this or edit it. So I'm just going to pick up where I left off, uh, sort of arbitrarily pick a place. Oh, here comes trouble. Now we've got the other cat coming in. No, no. Okay, I'm going to concentrate here. Um, Confidential information, you may not be able to protect it using the types of rights that you get from copyright. And again, I was saying that if I happen to see the recipe for Coca-Cola and I have a photographic memory and then I go home and write it down, copyright doesn't prohibit me from making Coca-Cola. Okay, so there's a type of information that you cannot. The value of the information doesn't reside in who has the ability to copy it. It's really the commercial plans, recipes potentially, but also, especially in the context of data analytics, whether it's algorithms, code, or insights, commercial insights derived from the data that may not be adequately protected by copyright and patent. Okay, but it might be a form of confidential information. Now, confidential information is not oof, here comes another cat, is not is not automatically protected by intellectual property law. However, under certain circumstances, you may be able to sue for damages using a cause of action called breach of confidence. Breach of confidence is sort of a unique type of cause of action. It isn't really derived from contracts. It's not really a tort. Um, but nevertheless, it has been recognized by courts in Canada as creating a basis for suing another party for damages. The requirements for establishing a claim of breach of confidence include the fact that the information conveyed to the disclosing party had to have been confidential. And again, confidential information means information has economic value as a result of not being generally known. Efforts are taken to keep the information confidential, and the information is not generally known in the industry. So, breach of confidence requires that those elements are true. It also requires that the information was communicated in a context or in circumstances in which a duty of confidence arises, such that a reasonable person looking at the situation would understand that the information being communicated was confidential and meant to be kept confidential, and the information was misused by the defendant, the person being sued, right? So essentially, you've disclosed confidential information to the defendant, the person being sued, in a context where it was clear that the information was confidential and was meant to be kept confidential, and the person to whom you disclose that information did not respect the confidentiality. They either sold the information, disclosed it, or used it themselves. Now, I'm going to tell you, you can't see this, but the truth is that I have two cats hovering around here, and they may touch the mouse pad. Don't touch the mouse pad. Let me see if I can show you here. This here is Flip. Say hi, Flip. And over here, where is Henry? This is Henry, right over there, sitting up there, black cat. And again, this is Flip. Say hi, Flip. Yeah, hi. Ooh, that's a little bit terrifying. All right, that's the feline portion of this lecture video. Hope you enjoy that. And I'm back to trying to add some normalcy to this video. Um, in the context of an outsourcing agreement, to protect your confidentiality in the information, to be able to argue potentially to a court in the future that, hey, no, this information was confidential, it's important that the contract's provisions reflect the fact that the information was viewed as confidential. So if you are disclosing information that you want to treat as confidential, and this could be not just in the relationship with the service provider, but with other parties, right? You need to make sure that you're treating information that is disclosed as confidential. And that typically means, hey, your contracts have to identify the information as being confidential. The contracts have to include requirements around keeping the information secure and private. Otherwise, you're going to potentially have difficulties establishing that the information was confidential because, arguably you're not taking efforts to keep the information confidential. So if the information is confidential, you have to act in a way that it's confidential. And that includes the types of provisions you're putting in your contract. Okay, I almost deleted this entire video. That would have been a disaster. It's been a rough couple days. Okay, let me get back here. Um, when we talk about confidential information, um, we also want to make sure that we include a carve out for derivative data and information that may result from the analytics processing of the data that you have, right? A lot of times when you're getting information, you're outsourcing data analytics services, and you're sharing, a database full of information. Um, it's not just the databases that are valuable, it's the insights from the databases that are very important. And those insights really, it's a name it and claim it type of proposition. You want to make sure that your contract explicitly recognizes that, hey, there could be derivative data that is created in the process of doing these data analytics services. And if there are derivative information types of products or derivative insights, you need to ensure that if you're the disclosing party, that you say, hey, any derivative insights that the data analytics service provider obtains belongs to us, belongs to the party hiring the person doing the data analytics services, as opposed to the data analytics service provider. In other words, just because they derive the insights, doesn't necessarily mean they automatically own it. And you need to ensure that you assert ownership over those insights in the terms of the contract. Now, an important piece of all of this is ensuring that you include non-disclosure provisions in your contract or have an entire non-disclosure agreement that comes along with the data analytics services contract to begin with. And here, this is part of um, making an effort to ensure that confidential information that's disclosed stays confidential. So you want to ensure that there are provisions in your contract that will support an effective non-disclosure type of regime governing this particular transaction. So you should include definitions of what is confidential information. The contract should include parameters for permitted uses, right? How can this information that we're being disclosed be used? How can it not be used? With whom can you share the information? If you're outsourcing to a data analytics company and there is a possibility that that company may in turn outsource it again, if you don't want that to happen, or if you want to ensure that there are adequate controls for any such arrangements, you need to ensure that you put that in the contract itself. Um, you should ensure that the contract clearly includes a duty of non-disclosure and duties related to keeping the information secure and confidential. These are also very useful in terms of ensuring that you meet your requirements under PIPEDA. And then I would recommend that there is a provision in the agreement that um, essentially establishes that if there is uh, uh, um, an alleged disclosure of the confidential information, that the company to whom the data belongs has the right to request or has the right to receive an injunction in a court. Now, an injunction is a court order to do something or to stop doing something. In a context of a non-disclosure agreement, the injunction would be to order the analytics service provider to stop disclosing information. Okay, so this is anticipating that there is a breach of the contract and the third party analytics service provider um, does start to disclose information in ways that violate the terms of the contract. You want to have a provision that says in those circumstances, you can get an order to a court order that says stop disclosing. Okay, a couple reasons why this is important. First, what happens if you get an injunction and the other party continues to disclose? That's actually a criminal offense. So that really ups the stakes and is going to make any person think very carefully about whether or not they want to disclose the information or not. You know, the fact that they may be arrested for doing so um, raises some very serious considerations and concerns and may just change the calculus of what they're doing. The other important dimension to this, and the reason why it's so important to have in the contract, is because an injunction is an equitable remedy. And that means that it is not automatic. You can ask a court for an injunction, but because it's an equitable remedy, the courts will look very, very carefully, generally speaking, at a situation to determine whether or not it's fair and reasonable and appropriate to issue an injunction. And when we're talking about information and communication, one of the court's big concerns and considerations relates to the importance of freedom of expression and the free movement of information and ideas. And so, if you don't have a clause in your contract that entitles you to an injunction, you're going to essentially be running uphill when you go to the court and ask it to impose an injunction all the same. The court is going to be really careful because of um, other values and interests related to the free flow of information in society. Courts are not going to readily give out injunctions ordering the other party to stop disclosure of the information. However, if you've got the right established in the contract in the first place, that changes the calculus because the parties here, right, they've decided, they've agreed in advance that an injunction would be an appropriate remedy. And the courts are going to assume that all other things being equal, if it's in the contract, you should have the right to exercise the rights set out in the contract, including the right to receive an injunction to prevent further disclosure. So um, essentially, it's going to make your life easier if, worst case scenario, the other party starts to disclose information in a way that violates the terms of the agreement. Okay, mercifully, I think, don't bite me. That's the cat. Sorry, he does bite. Mercifully, I think that this will cover the key information that I've wanted to disclose or share with you about some of the intellectual property dimensions of a contractual situation where you're outsourcing data analytics services. So you can consider this part A for the lecture. I'm going to stop the recording here, and then I'll create another video for the materials that were discussed in class after we completed the discussion of intellectual property considerations and essentially ownership of confidential information type of considerations in the contract. So from Flip. Say goodbye, Flippy. Let me see. Say goodbye, Flip. Say goodbye. Isn't he cute? He is, I know. And Henry, where are you there? And this is Henry. Say hi, Henry. Henry. Okay, he doesn't want to look up. He's being aloof, as he is wont to do. So from Dr. T here and the felines, wishing you a good evening, and I'll see you in the next video.